All right, so we're diving into some brand new employment regulations. These employment regulations 2024, they just dropped.
Yeah.
January 3rd, 2025, they were published. And they come into effect pretty soon.
Right.
April 1st.
Very soon.
I know. Going through these kinds of documents can be a bit of a chore.
Yeah.
But we're going to break it down for you, and we're going to find what's really important for you.
Exactly.
Whether you're an employee or an employer in ADGM.
Yeah, and it's I think it's interesting that these regulations are actually replacing the 2019 one, so quite a big change.
Okay.
Yeah.
So what's the big picture?
Wow.
What are we looking at here?
From the outset, you'll notice a really big emphasis on fairness and transparency.
Okay.
They're really designed to protect employees' rights and create a more level playing field.
So no more getting tricked into signing away your rights.
Exactly. Section 1 is all about that. It's called the no waiver clause. And it basically means you can't be forced to give up the minimum rights that are outlined in the regulations.
Okay.
Obviously, you can always negotiate for better terms.
Right.
And settlement agreements are still allowed, but there are very strict requirements in place to protect you.
So no more shady deals where someone's pressured to accept less than they deserve.
That's the idea.
Okay.
And speaking of shady deals, Section 2 cracks down on employers making false promises during the hiring process.
Right.
Imagine applying for a job with an incredible salary and amazing perks only to find out it was all a lie.
Ouch. That's going to be demoralizing.
It is.
Yeah.
And now it's straight up illegal.
Okay.
Employers cannot misrepresent anything about the job, the position, the type of work, the wages, anything.
Okay.
They have to be upfront and honest from the get-go.
That's a big win for job seekers then, right?
Yeah.
No more bait and switch.
Exactly. And it doesn't stop there. Before you even set foot in the workplace, there's the issue of visas and work permits.
Ah, the joys of paperwork.
Well, Section 4 makes it clear that the employer is responsible for obtaining and maintaining your work permit and any necessary visas.
Okay.
And here's the kicker. They cannot charge you for these costs.
Interesting.
Or hold visa cancellation over your head as leverage.
Wow. So no more stories of employers holding their employees' visas hostage.
Exactly. It's all about creating a fairer and more ethical hiring process.
Love it. Okay, so now we're in the door. What about that piece of paper, the employment contract?
Section 5 lays down the law on that.
Okay.
Everyone is entitled to a written contract, and it has to be in English.
Okay.
And it has to cover all the essential details, your job title.
Yeah.
Wages, leave entitlements. Notice periods.
Okay.
Everything.
So nothing left.
No more vague agreements.
Open to interpretation.
That lead to misunderstandings down the line. That's right. And even if you don't speak English fluently, the employer has to make sure you understand what you're signing.
Okay.
They can't just hand you a document and say, sign here.
That's really good. So we've covered hiring.
Yep.
What about once you're actually on the job? Working hours, time off?
The regulations have got you covered there, too.
Okay.
Section 15 sets the maximum weekly working time at 48 hours.
Okay.
Anything beyond that requires your written consent.
Yeah, right.
And could qualify for overtime pay.
Okay, so no more being pressured to work around the clock without fair compensation.
Exactly. But it's not just about the number of hours.
Right.
Section 16 prohibits employers
Okay.
from letting you work excessive hours that could harm your health.
Interesting.
Even if it's within that 48-hour limit.
Okay.
They're acknowledging that burnout is real.
Yes.
And that sometimes even sticking to the limit can be too much.
Yeah, that makes a lot of sense. It's about well-being and not just sticking to a number. Okay.
Yeah.
Let's talk about something a bit more fun.
Okay.
Vacation.
Ah, yes. Section 21.
Okay.
Guarantees you at least 20 working days of paid vacation per year.
That sounds pretty generous.
It is.
Yeah.
And you can even carry over unused vacation days to the next year.
Okay.
Up to a maximum of 12 months.
So you don't have to...
So you don't have to scramble.
Use it or lose it?
To use them all up before the year ends.
That's really good.
Right.
No last-minute vacation planning just to use it up.
It's a much more flexible approach.
I love it.
And speaking of time off...
Yes.
Section 29 covers sick leave.
Okay.
You're entitled to up to 60 working days of sick leave.
Okay.
In a 12-month period.
Wow.
But there are rules about notification.
Okay.
And providing a medical certificate if your employer asks for it.
So you can't just call in sick whenever you feel like it.
That's right.
But you are protected if you genuinely need time off to recover.
Exactly. It's about finding that balance between employee well-being and responsible use of sick leave.
Okay.
And of course, there's sick pay to help you manage financially.
Tell me about sick pay.
Well, it's a tiered system.
Okay.
For the first 10 working days of sick leave, you get 100% of your daily wage.
Okay.
Then for the next 20 working days,
Okay.
you get 50%.
Gotcha.
And for the remaining 30 days, it's unpaid.
Okay, so there's a real safety net there, especially for those unexpected illnesses
Exactly.
that can really throw a wrench in your plans.
It's about providing support when you need it most.
Yeah.
Now, besides vacation and sick leave, there are other types of leave available, like special leave for the Hajj pilgrimage,
Okay.
bereavement leave if you lose a close family member,
Right?
and of course, paid time off for national holidays.
So they really thought of everything.
These regulations are quite comprehensive in terms of employee rights and entitlements.
Okay, so now let's flip it. Responsibilities of employers.
Okay.
What are some of the key obligations that we're seeing here?
Part 7 delves into that, starting with Section 37, which outlines the general duties of employers towards their employees.
Okay.
It emphasizes the responsibility to ensure a safe and healthy workplace, both physically and mentally.
So it's not just about preventing accidents, it's also about creating a positive and supportive environment.
Exactly. Employers have a duty to protect employees from discrimination, harassment, and victimization, creating a workplace where everyone feels respected and valued.
Okay.
And speaking of safety, Section 38 outlines a whole set of health and safety duties, covering everything from ventilation and temperature to lighting, cleanliness, even the provision of drinking water.
It's like a checklist for employers to make sure they're meeting their obligations.
That's a good way to put it.
Okay.
And if an employee does get injured or falls ill due to work-related factors, Section 48 kicks in, obligating the employer to provide immediate medical assistance and cover the costs if their insurance doesn't.
So no employee should be left stranded without medical care after a work-related incident.
Exactly. And if the incident was caused by the employer's negligence, they could be held liable for damages.
So that sends a strong message about the importance of workplace safety. Speaking of health, what about longer-term coverage?
Section 49 requires employers to provide health insurance for their employees.
Okay.
And where applicable, their dependents, in accordance with the regulations set by the relevant authority.
So healthcare is not a luxury. It's a right protected under these regulations.
Yes, exactly. It's about recognizing that employees' well-being is paramount.
Okay, so we've talked a lot about employer responsibilities, but employees also have duties as well, right?
Absolutely. Part 8 outlines the general duties of employees.
Okay.
Emphasizing reasonable diligence and care in performing their work.
Okay.
Following instructions. Taking care of employer property. And maintaining confidentiality.
So it's about building a relationship of trust and mutual respect.
Exactly.
Both sides have obligations.
And those obligations are spelled out clearly in these regulations.
Okay, now let's get into something super important in today's workplace.
Okay.
Discrimination.
You're right. It's a major issue. And Section 53 lays down the law on that.
Okay.
It prohibits any adverse treatment based on your sex, marital status, pregnancy or maternity, race, nationality, religion, age, or disability.
So it's a comprehensive list.
It is.
Covering a wide range of characteristics.
And it goes beyond just blatant discrimination. It also covers indirect discrimination. Where a seemingly neutral policy or practice disadvantages people with certain characteristics. And of course, it prohibits harassment, creating a hostile work environment based on those protected characteristics.
So it's not just about what's explicitly said or done, it's also about the overall impact on the individual and the work environment.
And if an employer is found to have discriminated, there are serious consequences. The employee can take them to court, seek compensation, and even get the court to order the employer to make things right.
So it's about holding employers accountable and creating a truly inclusive workplace.
Precisely. And it's not just about discrimination. It's also about protecting those who speak up against unfair treatment.
Victimization.
Exactly. Section 54 prohibits victimization. Meaning you can't be penalized for bringing a discrimination claim, giving evidence in a claim, or even just reporting discrimination to your employer.
So you're protected if you speak up.
That's the idea.
No retaliation.
The law is on your side.
Okay.
And the remedies for victimization are similar to those for discrimination compensation.
Yeah.
Court orders to rectify the situation, the whole 9 yards.
So it's about empowering employees to speak up without fear of reprisal.
Exactly. Now let's talk about another form of speaking up.
Okay.
Whistleblowing.
All right, now this is where it gets even more serious.
Well, Part 10 is all about protecting whistleblowers.
Okay.
Section 55 states that you can't be penalized for making a protected disclosure,
Right.
even if it exposes your employer's wrongdoing.
So you can't be fired, demoted, or harassed.
That's right.
For blowing the whistle on unethical or illegal activities.
And the regulations go into great detail about what constitutes retaliation.
Okay.
It's a comprehensive system designed to protect those who dare to speak truth to power.
What if an employer ignores those protections and retaliates against a whistleblower?
They face the same consequences as in discrimination cases.
Okay.
Potential compensation court orders to fix the situation.
Right.
And even potential criminal charges in some cases.
Wow.
It's about sending a clear message that retaliation won't be tolerated.
So it's fostering a culture of accountability and transparency.
Exactly. Now let's move on to a topic that's a little less controversial, but equally important.
Okay.
Termination of employment.
Ah, the end of the road.
Well, every journey has its destination.
Right.
And Part 11 outlines how that journey ends in the context of employment.
Okay.
Section 56 deals with notice periods, which are essentially the amount of time you or your employer have to give before ending the employment relationship.
So no more sudden dismissals without any warning.
That's right. The general rule is 30 calendar days written notice.
Okay.
If you've been employed for 3 months or more.
Right.
And 7 calendar days for shorter periods.
Okay, so that gives both sides time to prepare, whether it's finding a new job or finding a replacement.
And there's flexibility built in.
Okay.
You can agree to a longer notice period.
Okay.
And employers can pay you in lieu of notice if you need to leave quickly.
Okay, so it's about being fair and reasonable on both sides.
Exactly.
But what if you're dismissed immediately without notice?
That's where Section 57 comes in.
Ah, termination for cause. What are the rules around that?
Well, it has to be for a valid reason.
Okay.
Something that a reasonable employer would consider serious enough
to
warrant immediate dismissal.
Right.
It could be misconduct, breach of trust, or something that fundamentally damages the employment relationship.
So it's not just a free pass.
No, not every.
For employers to fire people whenever they want.
And if you believe you were unfairly dismissed,
right,
you can challenge that decision in court.
Okay.
It's about protecting employees from arbitrary or unjust dismissals.
So it's about ensuring due process. Now, sometimes when an employee is terminated, there's a lot of anxiety, uncertainty about the reasons behind it.
Yeah.
Do these regulations address that at all?
Absolutely.
Yeah.
Section 58 grants employees the right to request a written statement outlining the reasons for their termination.
So it helps prevent those situations where you're left in the dark.
Exactly.
Wondering what went wrong.
Transparency is key even when the employment relationship is coming to an end.
I love it.
Yeah.
Okay, speaking of moving forward references. Yes, people need them.
Section 59 outlines the right to an employment reference.
Okay.
Upon the employee's written request, the employer must provide a reference within 21 calendar days.
Right.
This reference must include basic information.
Yeah.
Like the employee's name, dates of employment, job title, and if requested, their wages at the time of termination.
So no more vague or evasive references that leave you guessing.
The goal is to ensure that references provide relevant and factual information, facilitating a smoother job search for the employee.
That's a big help for people navigating the job market. It prevents employers from unfairly hindering their former employees' chances of finding a new job.
It's about ensuring fairness and transparency throughout the entire employment life cycle, even after the relationship has ended.
Yeah. So now let's talk about the financial aspects of ending employment. What happens to your benefits and your entitlements?
That's where things get a bit more complex.
Okay.
But the regulations provide clear guidelines.
Yep.
We can start with pensions,
okay,
which are addressed in Section 60.
Right.
This section applies specifically to UAE and GCC nationals, requiring employers to enroll them in the relevant UAE federal pension scheme and make the necessary contributions.
Okay, so ensuring long-term financial security for citizens and GCC nationals.
And it's important to note that these employees are generally not eligible for end-of-service gratuity, which we'll discuss next.
Right.
Unless they've opted out of the pension scheme with explicit written approval from the pension authority.
So there's a clear distinction between pension benefits and end-of-service gratuity.
Absolutely. Now let's dive into the details of end-of-service gratuity outlined in Section 61.
So this is what people think of as severance pay, right?
Yes. It's a lump sum payment you receive upon termination, regardless of the reason for leaving, after completing at least 1 year of continuous service.
Okay, so like a reward.
In a way, yes.
For your years of service.
And the amount you receive depends on your basic wage.
Okay.
And how long you've worked there. For the first 5 years, it's 21 days of basic wage. For each year worked. After 5 years, it jumps to 30 days for each additional year.
So the longer you work, the bigger the payout.
Exactly. And the regulations lay out the calculation method very precisely.
But can they deduct anything from that gratuity?
Yes, they can deduct any outstanding amounts you owe them, like unpaid loans or advances. It's about settling all financial obligations before you part ways.
Makes sense. Is there any alternative?
Yes, there is.
To receiving that lump sum?
Employers can offer you the option of participating.
In a pension or savings scheme instead?
Right.
This can be a good choice if you prefer a long-term savings plan for your retirement.
So it gives employees some flexibility in how their benefits are structured.
And it's important to remember that if you choose the pension or savings scheme, you generally give up your right to the lump sum gratuity.
Gotcha.
Unless you have a separate agreement with your employer.
So it's all about making informed choices.
Exactly. Now, before we move on to the final part of our deep dive, let's touch on one more logistical detail that often comes up when employees from overseas leave their jobs. Repatriation flights.
Getting everyone back home safe and sound.
Exactly. Section 62 obligates employers to provide a repatriation flight for employees upon termination, sending them back to their country of origin or another agreed-upon location.
So eases the burden of returning home.
Precisely.
After working in ADGM.
And employers can either book the flight directly
or reimburse the employee for booking their own flight.
So that offers some flexibility for everyone involved.
It does, however. There are some exceptions to this rule.
Like what?
For instance, it doesn't apply to remote employees who aren't residing or working in the UAE, as their return travel arrangements are likely already in place.
Makes sense.
It also doesn't apply if the employee finds a new job and visa sponsorship in the UAE within 30 days of their work permit being canceled, as they're presumably staying in the country. And finally, it doesn't apply if the employee is terminated for cause, as their departure is likely under less favorable circumstances.
So it's not a blanket rule that they've considered different situations.
Exactly. It's about being fair and practical in applying these regulations.
So we've covered a lot of ground in this first part
of
our deep dive, exploring those key rights and obligations for employees and employers.
From the hiring process and contract terms to working hours, leave entitlements, workplace safety. Discrimination whistleblowing.
It's been a journey.
And termination procedures.
We're not done yet.
We're not done yet.
In the next part of our deep dive, we'll look at the enforcement mechanisms.
We'll uncover the role of the registrar, the various sanctions and fines that can be imposed for violations, and the procedural safeguards that ensure fairness and transparency throughout the enforcement process.
Buckle up, everyone, because we're about to explore the teeth behind these regulations.
Yes, we are.
Stay tuned.
Stay tuned.
Okay, so we're back. And we're going to get into part two of this deep dive into the Employment Regulations 2024.
Exactly.
In part one, we went through all of those rights and obligations for both employees and employers in ADGM.
That's right.
Now we're going to figure out how these rules.
How do we enforce all of them?
Are enforced.
Yeah, let's get down to the nitty-gritty.
Yeah, what are the teeth behind these regulations?
This is where things get really interesting.
Okay, so who's the big boss who's making sure everyone follows the rules?
The key player here is the registrar. Think of them as a referee. Making sure both employers and employees are sticking to the regulations. They have a whole arsenal of tools at their disposal. Warnings. Fines. Even workplace inspections.
So it's not just about setting rules. It's about making sure that they're followed.
It's about enforcement.
I like it.
Yeah.
What happens if they suspect an employer isn't playing by the rules?
Well, first they issue a warning notice.
Okay.
It's like a yellow card.
Okay.
Outlining the alleged violation.
Okay.
And what the registrar plans to do about it.
So, a heads up.
Exactly.
A chance for the employer to explain themselves.
The employer gets at least 14 business days.
Okay.
To respond to the warning notice, explain their side of the story.
Okay.
And provide any relevant information.
Right.
The registrar also has to give them access. Okay.
To any material that led to the warning notice in the first place?
Yeah.
Transparency is key.
So no one's judged without a chance to defend themselves.
Right. It's all about due process.
Okay.
Now, after considering the employer's response, the registrar has a few options.
Okay.
They can drop the case if they're convinced there was no violation.
Okay.
They can revise the warning notice with different actions if necessary.
Right.
Or, if they're not satisfied, they issue a decision notice.
Okay, so that's like the final verdict.
Precisely. It's a formal document stating the registrar's final decision,
Okay.
including any penalties or sanctions.
Right.
And it's all laid out in writing.
Okay.
With clear reasons for the decision and information on how to appeal if the employer disagrees.
So there's checks and balances.
Absolutely.
The employer has the right to challenge the decision.
They can take the matter to the ADGM courts.
Yeah, okay.
If they believe the decision was unfair or incorrect.
So it's all about fairness and accountability.
It is. Okay, what about the information that the registrar uses to build their case?
Mm-hmm.
Can they just access anything?
That's a good question.
They would.
There are limits to what they can use.
Okay.
The regulations define certain types of information as protected items.
Okay.
Things that can't be forced into disclosure.
Okay.
This includes confidential communications between lawyers and their clients,
Good.
documents related to legal proceedings, and anything else protected by other laws.
Okay.
So even if the registrar happens to have these protected items, they can't be compelled to reveal them.
Okay.
But they do have to inform the employer that these items exist.
Gotcha.
And that they have chosen not to grant access.
Transparency. Okay.
Yeah.
Let's talk about publicity.
Okay.
How much of this enforcement process becomes public knowledge?
Well, when it comes to the warning notice, everything is kept strictly confidential.
Okay.
Neither the registrar, the employer, or anyone else can publish that information. Okay. It's all handled behind closed doors to protect everyone involved.
So no trial by media in the initial stages.
It allows for a fair and impartial investigation without unnecessary public scrutiny.
Now, once the decision notice is issued.
However, once the decision notice is issued, the registrar has the power to publish it.
Okay.
Or parts of it.
Right.
However they see fit.
So they control what information gets released to the public.
Exactly.
All right.
But they have to consider the fairness of publication, the potential impact on the employer, as well as the overall interests of ADGM.
Okay.
It's a delicate balance between transparency and protecting reputations.
So justice is not only done, but seen to be done.
Precisely.
But being mindful of the consequences of public disclosure.
Yeah. And remember, no one else can publish the decision notice or any related information without the registrar's express permission to get the final say.
So it's a tightly controlled process. What about those situations where an employer might be bending the rules?
Okay.
But it's not quite a clear-cut violation. That warrants a warning or a decision notice. Do employees have any options in those cases?
Yes, they do. Section 72 provides a broader avenue for seeking redress.
Okay.
If an employer breaches their obligations under the regulations, an employee can go to court and ask for a declaration that a breach has occurred.
So they can formally raise concerns?
Exactly.
And seek a resolution?
And the court can order the employer to fix the situation, telling them to comply with their obligations.
So it's not always about punishment.
Not always.
It's about making things right.
It's about making things right.
These regulations have real teeth. And that employees aren't left without recourse. If their rights are violated.
Absolutely. And if the regulations don't specify a particular remedy for a specific breach, the court can also award compensation to the employee for any losses they suffered as a result of the employer's noncompliance.
It's another layer of protection. Throughout this deep dive, we've mentioned the standard fine scale.
Oh, yes.
What is that?
It is.
And how does it work?
It's a system established under the Commercial Licensing Regulations, Fines, Rules, 2020.
Okay.
And it outlines a range of fines.
Okay.
Categorized by levels.
Okay.
Each level corresponds to a specific monetary amount.
So the more serious the violation, the higher the level.
Exactly.
And the bigger the fine.
That's exactly it. It's a structured approach to ensure consistency and fairness in how penalties are determined.
Making sure the punishment fits the crime.
Precisely. Now, apart from fines,
okay,
there are also fees that employers might have to pay to the registrar.
Okay.
These fees cover the costs of administering the regulations and providing various services.
So it's like a service charge.
You could say that.
Okay. And the board has the power to set rules about these fees.
Okay.
How much they are, who has to pay them, and so on.
So there's a flexibility in how those are structured.
Yeah, it allows for flexibility in adapting the fee structure to different situations.
Okay, now I know we've been throwing around some legal jargon. Don't worry.
A little bit.
There's a glossary to help decipher it all.
There is.
Like a dictionary for legal terms.
Precisely. Section 74.
Okay.
Provides a comprehensive glossary of defined terms.
Okay.
It explains all those key words and phrases that have specific meanings within the context of these regulations.
So no more getting lost in translation.
Exactly.
Okay, before we wrap up, who do these regulations apply to?
Excellent question.
And when do they come into effect?
Section 75 lays it all out.
Okay.
First, these regulations are officially titled the Employment Regulations 2024.
Okay.
They apply to all employers and employees working in ADGM. That's right, with a few specific exceptions.
Okay, who's exempt?
First, we have employers who hold dual licenses.
Okay.
One from ADGM and one from the Abu Dhabi Department of Economic Development.
Okay.
Their employees are already covered by the UAE labor law.
So no duplication.
So these new regulations don't apply.
Everybody's under one set of rules.
It's about avoiding duplication.
Right.
And ensuring everyone is under one clear set of rules.
Okay, anyone else?
Yes. Employers who have been granted a specific exemption by the board under the Commercial Licensing Regulations Exemptions Order 2024 are also exempt.
Right.
These are likely handled on a case-by-case basis, considering the specific circumstances.
So there's some flexibility there.
Exactly. And finally, it's crucial to remember that these regulations come into force on April 1st, 2025, replacing the 2019 regulations.
So mark your calendars.
Yeah.
April 1st is not just April Fool's anymore.
It is also the day that these new employment regulations become the law of the land.
That's right.
In ADGM.
It's a major milestone.
Yeah.
Marking a shift towards a more modern and equitable approach. To employment in the ADGM.
So I think we've covered a lot of ground here.
I think so.
In the second part of our deep dive.
That's a lot of ground.
We've unpacked the enforcement mechanisms.
The teeth
behind these regulations, making sure they have real impact.
Yeah.
We've explored the role of the registrar.
Yeah.
The sanctions.
Yeah.
The fines. The procedural safeguards. And those exceptions and timelines.
All those little details.
Yeah. It's been a journey.
It has been.
Through the legal landscape of employment in ADGM.
But there's more to come.
There's one more leg of this journey.
One more leg.
Ahead.
That's right, in the final part of our deep dive.
Okay.
We'll step back and look at the bigger picture, considering the broader implications of these regulations and what they might mean for the future of work in the ADGM and beyond.
So stay tuned for the grand finale.
The grand finale.
Of our deep dive.
That's right.
Into the Employment Regulations 2024.
Stay with us.
All right, so welcome back to the final part of our deep dive into these Employment Regulations 2024 for ADGM.
Yeah.
We've gone through so much.
We have.
From the very first step in the hiring process all the way to the very end with termination.
All the intricacies.
And everything in between.
The ins and outs.
But I want to take a step back.
Okay.
Look at the big picture here.
Yeah.
What is the overarching message? What do these new regulations tell us about the future of work in ADGM?
What's really fascinating here is that these regulations signal a clear shift towards a more employee-centric approach. There's a real emphasis on fairness, transparency, and a genuine recognition of employee rights.
So moving beyond just a purely transactional
exact view of employment. Employees aren't just cogs in a machine.
No, they're individuals.
Yeah.
They're people.
With needs.
With aspirations.
That deserve to be.
Respected and protected. protected.
And protected.
And by providing this really robust framework of protections and entitlements, these regulations aim to cultivate a more equitable and harmonious working environment.
So creating a space where both employers and employees can thrive.
Exactly.
Not just survive.
Just survive.
It's a win-win.
Absolutely. A happy and engaged workforce is ultimately beneficial for everyone. Leading to a more productive and prosperous economy.
Now, we focused a lot on the letter of the law, dissecting those specific provisions and requirements. What advice would you give to someone navigating this landscape? Whether they're an employer or an employee?
I think first and foremost, knowledge is power.
Don't just assume that you know how these regulations apply to your specific situation.
So don't just take our word for it. Go to the source.
Exactly. Take the time to really read through the full document.
Right.
Understand the nuances. Familiarize yourself with those key concepts. And don't be afraid to seek expert advice if you need clarification on certain points, or if you're dealing with a complex situation. There are plenty of resources available, including legal professionals specializing in employment law who can provide tailored guidance.
So be proactive.
Be proactive.
Be informed.
Be informed.
So important.
Absolutely. And remember, the legal landscape is constantly evolving.
Yes.
New rules and interpretations emerge. So make it a habit to stay updated. Check the ADGM website, legal news sources, or consult with those legal professionals to ensure that you're always in the loop.
You got to keep learning and adapting.
You do.
To stay ahead.
To stay ahead.
One final thought. We've talked about the legal remedies if your rights are violated. But what about those situations where it's not so clear-cut? Where there's a disagreement or a sense of unfair treatment, but it doesn't necessarily rise to the level of a legal violation.
That's a great point. Not every dispute needs to end up in a courtroom.
Right.
And while these regulations don't prescribe specific internal grievance procedures, they strongly encourage employers to establish clear and accessible mechanisms for employees to raise concerns and seek resolution within the organization.
So open dialogue, early intervention.
Exactly.
Addressing issues before they escalate.
It benefits everyone.
To formal disputes.
It allows employees to voice their concerns in a safe and confidential space. And it gives employers a chance to address those concerns promptly and effectively.
It's a win-win.
It's a win-win.
So it's about fostering a workplace environment where communication and respect are paramount.
Absolutely.
Even when disagreements arise.
Even when disagreements arise.
And even if it can't be resolved internally. Going through that process can really help to clarify the issues.
Exactly.
And show that good faith effort.
To find a solution.
Demonstrate a willingness to engage in constructive dialogue. Which can be helpful. If the matter does end up in court.
It shows that you're committed to resolving issues amicably and fairly.
It does.
I think that's a perfect note to end on. We've explored these employment regulations inside and out, the ins and outs, from the specifics to the bigger picture.
From the micro to the macro.
What this means for ADGM, rights, obligations.
Enforcement mechanisms.
Communication.
Open communication.
Dispute resolution.
Early dispute resolution.
It's been a deep dive. I hope our listeners feel empowered and informed, ready to navigate this new landscape with confidence.
Knowledge is power.
Knowledge is power.
Understanding your rights and obligations is so important.
It's crucial.
In today's world.
In today's ever-evolving world of work.
Stay curious. Stay informed.
Yes.
And as always, keep those minds engaged.
Keep those minds engaged.
That's it for this episode of The Deep Dive.
That's it for today.
Until next time, keep exploring.